covered the Skibicki trial, came in every day. I noticed a lot of cultural sensitivity when it came to the Indigenous community. The families also thanked, the court for that in the end of the process. Can you tell me a little bit about, how those changes came to be?
Well, we're trying to be, generally speaking now, in the work we do and the processes that we offer up, generally, particularly when it comes to Indigenous litigants, Indigenous victims, and our larger attempt at judicial reconciliation, which I hope we can talk about in a moment as well, to be more sympathetic, more empathetic, and more sensitive generally to what those Indigenous actors and participants need or might want. So that was partly the reference point. Skibicki is such a unique situation in the sense that it really was, for so many people, emblematic of everything that the missing murdered women and girls inquiry was all about. So it was in some respects a metaphor for all of that. So we really had a responsibility, I think, obviously to ensure that the accused in that case had a fair trial, and we certainly tried to do that, and I think we succeeded. But we also had a responsibility to ensure that the deeply felt trauma by all the victims' families, but also the larger community, Indigenous and non-Indigenous, because this was deeply felt by many, many Manitobans, was properly addressed in a trial that validated the process, but at the same time obviously did what a court has to do, which is to ensure that due process was offered to the accused. So you were there, Tiar. You saw at various points the efforts we made to ensure that there was present in the courtroom certain things that I think were meaningful. The Crown was definitely animated by the need to be sensitive as well. And to the defense counsel's credit, they were as well, I think, understanding that this was a trial that, yes, it was a criminal trial like any other trial, but it required, I think, a level of sensitivity and a level of understanding that, however it would end, would be better concluded if it offered up to all observers those, I think, gestures of empathy and understanding. And I think that's what happened. But it was one trial, an important trial, a significant trial, in many respects a symbolic trial, not just for what it was representing in terms of the legal issues, but also for our court's efforts at judicial reconciliation. And that's an important initiative that we're obviously actively pursuing, as are other institutions in Canadian society.
Yeah, and you mentioned it, the National Inquiry, legal document. I was fortunate enough to work for that inquiry. I traveled with them, but, that document, I'm guessing you read it?
Yes.
You want to speak to just to talk in general about, the calls to justice and how you're trying to implement those here?
Well, again, we're like Skibicki. Skibicki was an example of how we can be sensitive to, obviously, unfortunately, the tragedies that we're now forced to deal with. The justice system obviously involves many actors, so we're not involved in the investigative role, we're not involved in the prosecutorial part of things. We simply adjudicate, we judge, we assess, whether it's a judge alone or with a jury. But to the extent that those cases come to us, I think we have a real responsibility to ensure that we handle them as quickly as we can. That's the first way that we can potentially victimize victims and victims' families if we're not dealing with them quickly, but also if we're not dealing with them in a way that's sufficiently, I think, sensitive, empathetic, and responsive to what are the unique challenges facing that type of investigation, that type of prosecution. So, we have to be humble with respect to how much we can do in responding to some of those recommendations, but there's a lot we can do. And I like to think Skibicki, in some respects, represents a good first effort. It's not the only effort. It won't be the last effort, but it's a good first effort at responding to probably the most tragic example of that case in Manitoba. And we've had a lot of them. So I'm not trying to set up a hierarchy of tragedy or pain, but that one is the most recent and certainly, for many people, the most acute.
And then, the one yesterday there, the Woodhouse, his conviction, 50 years, and then you were the one sitting behind you there today, and let's talk about that trial and the injustices within that.
Well, it's a tragedy, and I can, as a judge, I have to compartmentalize many things. I hear horrible cases, particularly in the criminal realm, that involve human suffering. But part of my responsibility is to be able to kind of move forward and get on to the next case without letting the last case, the last tragedy, sort of overtake me or envelop me. I think I can do that. I'm not insensitive, but I can do that. I find cases of wrongful conviction and miscarriages of justice much more difficult to sort of compartmentalize. Not because they're worse, but they're just so unique. Anytime, and I'll speak to two issues, the failures of the system generally, and then the presence, in this case, of this systemic discrimination. Anytime the justice system fails because of the deficiencies that naturally attach to a system made up of imperfect human beings, it's potentially problematic. And I don't like to see those types of imperfections, because our margin for maneuver, because the stakes are so high, is very, very slight. So we can't afford to make a lot of mistakes. So when it happens because of bad identity, a lack of disclosure, the way the case might have been prosecuted, or the way the case might have been adjudicated and judged, that's not a good thing. But if you throw into all of that the other deficiencies that can, along with all the other deficiencies in the system, this presence of systemic discrimination, it's tragic at a different level. And that's what we had in yesterday's case. I don't want to talk about any one particular case, but I've been involved in other cases like that, particularly the same case involving, I think, Mr. Woodhouse's brother 2 years ago. Same sort of thing. Those are cases for which the system has a hard time offering an explanation. But we have to provide an explanation. And we also have to, where we can, redress that issue. And we have to, where necessary, particularly when we know it's required, offer apologies. And we can't gain the trust, for example, in this case of the Indigenous community, in a system if we can't ourselves address where we fell short, particularly where we know the shortcomings were in part connected to systemic discrimination. We need, obviously, all Canadians to believe in the justice system, and we need Indigenous Canadians to trust the justice system as well, knowing as well that there's all sorts of initiatives now for the on the part of the Indigenous community to create in their own way their own space for achieving justice in the areas of child protection, and in some cases perhaps even in the criminal law. But to the extent that we are still serving Indigenous litigants, victims, and accused persons, we have to provide a system that can be trusted, that can be validated. And one of the ways we have to do that is when we see cases that can be identifiably called as or described as involving systemic discrimination, we have to call it out, and we have to address it, and we have to apologize for it. That doesn't mean every case. We still are a system, I think, that can be trusted, but the perception is such that we have to do better. So every opportunity we get, whether it's a Clarence Woodhouse or whoever, we have to identify what happened, and we have to be, I think, honest enough with ourselves to describe what happened and offer the requisite apologies.
Yeah, that's interesting. And then, so you became Chief Justice, was it 2011?
Yeah.
So you've been here now, my math, what is that, 13 years?
Yep. And it was,
in your role.
Yep.
Over those years, what are some of the changes you've implemented generally, but also, in relation to Indigenous people?
Well, let me come back to judicial reconciliation in a moment, because that's a big thing, and I want to sort of make sure we address that, because that's important for not just, as I say, this institution in which I'm involved, the judiciary and the Court of King's Bench, but I think all institutions in Canadian society. When I became chief in 2011, I'd already been the Associate Chief Justice for almost 3 years prior to that. Understand, as you do, Tiar, that as with all Canadian citizens, every time an Indigenous citizen comes to our court and has something that has to be addressed, redressed, or they're an accused person. One of the things that's important is obviously their capacity to have access to justice. Access to justice can mean all sorts of things. It can mean things that are too costly, things that are too complex, or things that are too slow. So in every area where we've tried to make improvements, and they don't just relate to the Indigenous communities, but a lot of them do, we've tried to make things less costly, less complex, and more quick. So two examples to just cite what it is I'm trying to sort of identify. One is child protection. Child protection, it's been a mess, and children are being apprehended in ways that are very, very traumatic for Indigenous families. And I know, and you know, that there's efforts, and there's federal legislation that are trying to kind of find ways to decentralize and to give back to the communities a greater participation and a greater control over that. So that'll take its course in the natural order of things. But to the extent that we are still involved in that area, the Family Division brought in some very important reforms that, in the context of these tragic apprehensions, sped up the process by which possible family reunification could occur. And at the very least, what we stopped, because it was happening for too long, is a situation where these kids who were apprehended were in limbo, sometimes for 24, 36 months. And bad things happen when children are apprehended and they remain in limbo. Phoenix Sinclair is a good example, right? And there's many examples. So that was an important step. That doesn't address the tragedy of how and why children are apprehended. So I'm not trying to suggest that we've addressed that. That's a different issue. It's an important issue, and I think Indigenous families themselves, Indigenous communities themselves are trying to deal with that by taking back, obviously, some of the jurisdiction they believe they should have to better deal with this. But to the extent we are dealing with stuff like that, we've tried to make it more quick. Similarly, in the criminal law, we've tried to do that as well. Because as you know, unfortunately, it's more likely once an Indigenous person is arrested for that person to be denied bail. They don't get out. So the socioeconomic realities make it much more difficult for them to get out on bail pending a trial. So the longer they're in custody, particularly if the delays are long, the more suffering they incur and their families incur. So obviously they deserve due process and they deserve adjudications as quickly as possible. So we've tried to improve that. So that's on the sort of judicial front in terms of the services we offer. Mm-hmm. But we've also, I think most importantly, on a broader scale, offered, I think, since about 2017, I did a speech to at the call to the bar in 2017, where I struck a committee. It's called the Trust, Reconciliation, and Access to Justice Committee. So it's TRAC in short. So trust is an important part of what we're trying to do. Access to justice is an important part of what we're trying to do, the reconciliation piece, but also the idea that we're trying to implement some systemic change. So this is a committee made up of about 7 or 8 judges and now 5 community members. Some significant participation by Indigenous community members, which really has added and enhanced the work we're doing. It's built on basically 4 pillars. The first is trust. And by trust, I mean we're trying to go out to the communities and earn their trust, trying to open up a dialogue, trying to engage with them, and we're trying to do outreach. Now, normally when judges do outreach with the community, we're out talking about the justice system, we're trying to explain the justice system, and we're trying to, in some ways, talk about why it's a good system. And we still believe that. But that's not what we're doing in the context of TRAC or this committee. We don't want to go out to Indigenous communities and when we're speaking to Indigenous leaders to be seen to be bragging about a system that they perhaps don't trust. So what we're trying to do when we do this outreach on this trust component, this trust pillar, is earn their trust by listening to what they want, listening to what we can do better, listening to how we perhaps need to better understand the lived experiences of Indigenous communities and the identifiable problems that they want us to be more empathetic towards. We're not guaranteeing results, obviously, but we're trying to open ourselves up. So in that sense, we're trying to earn their trust by doing outreach. But it's not the same type of outreach we would do, for example, in the ordinary course, because I don't think Indigenous communities want us to go and tell them how good our justice system is. They want us to listen. And that's sort of the fundamental, I think, first distinction about that pillar. The second pillar is the educational pillar. We were talking about that earlier on. Again, we're not educating others about the justice system. We're educating ourselves about Indigenous legal traditions, Indigenous legal orders, those things that I think are increasingly part of what it is Indigenous leaders and Indigenous communities want us to understand and, in fact, incorporate and integrate to the extent we can into our own processes. And you saw a little bit of that in Skibicki, not in the actual trial process, but in the presence of the various things, both during the trial and at the sentencing. As well, the education is basically exposing ourselves to individuals who come and teach us and talk to us about those things, those lived experiences, those reference points that we should have in our mind. Nagan Sinclair, for example, came and did a half morning on UNDRIP, and judges were very interested and very engaged. We have laws at lunches where other Indigenous leaders or professors, teachers, or community members come and speak to us. We're not doing enough sort of in community or on the land training yet, but we're planning that as well. But all of that is part of the educational component. Again, it's exposing us to things that will make us hopefully a little bit more empathetic and aware, as I say, of the lived experiences of others. And we'll have a better understanding of what the system is not doing or what the system is doing, but how that system still has to be refined. The other two pieces are relate to systemic change. Big systemic change and smaller systemic change. The smaller systemic change are those things that we can do relatively easily that we should have done a long time ago. So a good example of that is what we did 2 or 3 years ago when we brought in the eagle feather. Really meaningful, I think, step, but it wasn't done, and it was a relatively easy thing to do. So something like that is a small but important, as I say, meaningful change that we can bring. The bigger systemic change involves ways that we might collaborate with or sometimes get out of the way of initiatives that are being brought by Indigenous communities in respective ways they're assuming now what they believe is their own jurisdiction. And you're going to start seeing more and more of that, I think, in child protection. And you're going to start seeing the development of that as various courts, including the Supreme Court of Canada, address the extent to which Section 35 and the Indigenous right of self-determination plays out and evolves in a fashion that's going to require courts maybe to re-examine how we either work with, collaborate, or coexist with, as I say, Indigenous justice systems and certainly Indigenous legal traditions. And ourselves as well, even while we await that, how do we integrate into our processes as they exist now, to the extent that we have Indigenous litigants coming to our court? How do we integrate Indigenous legal traditions and legal orders in a way that makes the result and what we're doing not just more comprehensible, but more legitimate in the eyes of Indigenous communities and people?
Excuse me. Yeah, it's really interesting, like, if you think in context of how far we've come since you first started, because back then I recall, the Indigenous community was fighting a lot to get recognition, first of all, of that we're not just the stereotypical drunks and everything else back then. And then now we're at this point where, buzzwords are like, because of stuff like the Truth and Reconciliation Commission, we always talk about, reconciliation. So reconciliation is two parts, right? It's you listening to us, but also us listening to you in that context. And by the sounds of things you're saying, that's happening here.
Well, we're trying to build, it's all about relationships, right, and trust. And it's not always easy, because I think there is distrust on the part of members of the Indigenous community towards the justice system. And I understand that. And I'm not resentful of that. I understand it, because it's in some respects predictable, given the perception of what's happened and how the justice system hasn't always been as responsive or as open and as transparent to those legal traditions that you and I were just talking about. I myself, have over the last number of years, I don't want to paint myself, Tiar, as somebody who always was attuned as I should have been to the distinct requirements or even expectations of the Indigenous community when it comes to the law. That's part of an education of someone, and I hold myself out as an example of not someone who was some dinosaur, that's not what I'm saying, but someone who thought himself to be fairly enlightened, but really wasn't that enlightened. But the hopeful part of that is, as my time in a leadership position in the courts, I've been able to expose myself, to social context training and to other types of training that have allowed me to kind of become more empathetic and appreciative of the lived experiences of others. But also it comes with these relationships. I mean, when I have lunch with an Indigenous leader or an elder, or I interact on our committee with these 5 community members who bring their own unique perspective, you can't help but sort of question your own premises, and it's a way of keeping yourself honest and objective about what it is you're doing and how much you're doing. So it's about relationships, it's about opening yourself up, and I'm hopeful that every institution can experience what we're experiencing. And we're far, again, I want to be humble about this, we're still in the early stages, even if we've been going now for 5-6 years. This is a long-term project. The project of reconciliation, if you were to speak to Maurice Sinclair or anybody who was present at the creation, if you will, of that concept, they know it's a multi-lifetime project, and I myself have to be realistic about how much I can do. But it is starting, and it's starting in a hopeful way. And if there's one message I want to send to Indigenous communities across Canada, but specifically in Manitoba, is that there are institutions, increasingly large number of institutions, that are aware of their responsibility and aware of the potential to earn this trust and have this new mutual, I think, respect and dialogue. There'll be differences and there'll be distinctions and there'll be ways that we're going to have to kind of bridge, but that's progress, and that's, I think, really, in my view, a promising development.
Yeah, absolutely. And speaking of opening up, I mean, without being specific on any trials, but with your reflection, is there any on the early years that you think that you could have done differently in relation to understanding more the complexities of Indigenous issues?
Oh, for sure. I mean, I used to travel to some of the northern communities when I was with the provincial court many years ago. I'd been on all 3 courts in the province, the Court of King's Bench and the Court of Appeal, but also the provincial court. And there were times in my early career that I saw the inefficiencies of the court process when we went, for example, to a community, to be an inefficiency that was affecting the system, rather than maybe a problem that was representative of the way we were interacting with the community and individuals who were present to receive what it was that the court believed was justice. Could we have done more to interact with the communities? Absolutely. Could I have done more? Absolutely. The idea that we, at that point in time, were even in a position where we had to reconcile ourselves to a reality that obviously was unfair for many, that was still, I'm not saying it was unheard of, but it was still not an accepted fact on the part of many people who worked in institutions like mine. So that's an example of where I, like so many other people, have grown. And the provincial court are doing all sorts of new things themselves. So they're not divorced from, obviously, this effort as well. I don't think any court anywhere in Canada can afford to be. So, but back to your question, is there things that I can identify in terms of my slower development than I would have liked in terms of understanding the plight of Indigenous Canadians when they were coming into the court system? All sorts of things. I just, but now that I'm in a position of leadership, or since I've been in a position of leadership, we've tried to hopefully walk in lockstep with some of the efforts that have been made society-wide. But I don't think it serves any purpose for people who, like me, worked in a system like this to not recognize that they couldn't have done better. That's part of, I think, self-insight. And I'm not going to sit here and pretend that I was always as clear as I should have been with respect to what could have been done. But that's why I think now many of us want to want to move forward, and we're impatient to do all we can to the extent that we occupy positions of some power and influence.
I mean, that's life in general, right? We should be willing to be better than we were yesterday. Speaking of that, one of the things I noticed, and it might not just, I don't think it is even just in particular to Indigenous people, but written decisions, obviously you need the legal jargon and everything to explain things in its context, but I find they're more regular day-to-day English. People understand them a bit more. Want to talk about that?
Sure. Well, there's been a real effort by the judiciary over the last 10 to 15 years to do plain language communication. So whether it's in their oral communication or in their written communication, and this obviously impacts Indigenous Canadians like all Canadians. So this isn't just an issue that's meant to address obviously our interactions with Indigenous litigants, but all litigants. I mean, we want to be understood. We always talk about being transparent. That's an important thing. We want people to see what we're doing and why we're doing it. Mm-hmm. But we can't say we're doing that if we're using, $1 million words. I sometimes use the odd word that I probably ought to rethink, and I have people telling me that. But we do try to be more aware of that in the sense that we're trying to communicate what it is we're doing, and why we're doing it. And it's called plain language. You got it exactly right. I couldn't say it more plainly than you just did. It's an effort to just be more clear.
Yeah, and in our world, we kind of gauge it to not that it matter, but grade 6 language where people even younger generation could understand. So that's where we kind of try right our level at, right? So yeah, that communication is important. Is there anything else? Or let's talk about UNDRIP from your perspective.
Well, UNDRIP is a thing. It's now been adopted in a way in Canada where we as a judiciary have to deal with it and have to understand it and understand that it's going to have implications for how we interpret our own governing law. And it's, again, one more way, if we're sensitive and knowledgeable about UNDRIP, and that's not a small matter. There's still, I think, many people who work in the legal community who don't know as much as they should about UNDRIP. If we do learn about UNDRIP, we understand what it is that it's trying to do, what it's recognizing, and what the reference points are in terms of our current task in a given case, we're going to be even better placed, I think, to be, as I say, sensitive to and able to bring a perspective that will better reflect what it is we have to do when we're dealing with issues that touch Indigenous issues, whether it's a duty to consult case, whether it's a matter in the criminal realm, or whether it's a matter respecting a child welfare issue. All of that is now going to play out in ways that I think are going to be in some way connected to the broad principles and ideals of UNDRIP. So we have to deal with it.
And you said you got training about it from Niigaan. Are you thinking of ways already to how to implement that within, here in Manitoba?
Well, we have to kind of wait, Tiar, in terms of the cases that come. We can't go searching for cases where we can say, okay, this is an interesting, UNDRIP case where we can incorporate those. There'll be cases that will lend themselves to some type of analysis that will bring something relevant about UNDRIP into the interpretation or application of our analysis and maybe the governing law. So it's more just a case of learning about UNDRIP, knowing that it's there, knowing what it is, knowing how it might be relevant in a given situation, and then when you're facing a situation where it has some potential application, being able to know how to apply it. So that's why, sessions like the one that Niigaan Sinclair did for us is useful. But we also have a responsibility to educate ourselves too and ensure that we're up to speed, as it were, on all law that might have application in Canada. So, what about you, Tiar? Is there anything that, from your perspective as a reporter with, for example, APTN, that you find the courts fall short on that you'd want to talk about?
Well, I mean, every reporter's dream is the ability to come into the court and have our cameras here and tell stories that way, right? To be able to have that. And from my understanding is we have to put in an application, but it's not always granted.
Well, that's a difficult issue. I mean, I was a fairly strong supporter of a more enhanced openness when it came to cameras in the courtroom. And if you go back to my early days as chief, we made lots of efforts to improve that. We've kind of stalled a little bit. Part of the problem is every judge has a discretion based upon the given situation at hand to decide whether they're going to permit cameras to come into the courtroom. There hasn't been, as it were, a cameras in the courtroom gavel-to-gavel coverage of a trial. We contemplated that, and I'm not saying that it can ever happen, but it hasn't happened yet. But sentencings have, in some instances, been covered. The reading of reasons by judges. Some constitutional cases were covered with the reading of reasons by the judge. I think there's lots of room for that. The problem is the media themselves have to be willing, I think, sometimes to go to the expense, and it is expensive, I recognize that, to bring emotion and to face the possibility that it might not be successful. But we also began an initiative a number of years ago where we basically created a presumption that some cases would be telecast. That policy and that initiative never really took off for a few reasons, but it's perhaps time to maybe revisit that to some extent. But I certainly encourage the media under the auspices of the open court principle, if they feel they want to try to bring the cameras in on a given case or in a given situation, to make efforts and make attempts to have that happen. I can't guarantee the result, but I do know that if we don't move forward on that with the media taking a bit of a lead, we're not going to make a lot of progress on this. And this is one of those files where the courts try to be proactive, but there's so much else we're doing. We're not going to go out and necessarily search for this issue as one that we want to champion ourselves. Although we did try to do it in the early 2010s.
The other struggle, and I see it too, is trying to be better reporter, trauma-informed approach, but also if we did have that full access, how would that coverage play out?
So when you say full access, what?
Well, I just
what
meant
say
for me, if we were, say, the Skibicki trial, we were able to have our it would look crazy with all of our cameras, but a camera pool in here and just covering it and having that ability to do that. And I just think, looking at it from a trauma-informed way, all that information that came out in that trial, is that necessary for that to be out in the public?
That's a good question. I mean, that's one of the dilemmas, right? So how do you balance? How do you find that proper calibration of openness and transparency that comes with cameras in the courtroom, but at the same time, the type of respect that tries to acknowledge the dignity that's owed to families and victims, and it's difficult. That's why you're making the very point that I was trying to sort of less effectively make myself. You're going to get judges in some instances in tough cases like Skibicki. I'm not saying that I would have said yes, would have said no. No application was formally made. But that's the dilemma facing judges. How do they walk that line? How do they thread the needle? Where's the sweet spot where you can open up, but at the same time not in some way run afoul of maybe the public interest by disrespecting, as I say, the dignity of families and victims. So